It is lovely to see you here for the law school's celebration of Constitution Day and to see many of you here in person, which is exciting after a year plus of no in-person events like this. My name's Deborah Whitis. I'm the Associate Dean for Research, and I have the honor of moderating this fabulous panel of my colleagues, thinking about the Constitution and the current Supreme Court and what we might expect. Just so you all know in terms of logistics, so COVID being what it is, we are experimenting with new formats, and so thank you for being cooperative as we sorted through what to do to keep everyone safe. So we have people here in the moot courtroom, we have an additional spillover in-person room, and then we have folks on Zoom. My hope is that everyone is part of this conversation, and to make that happen, when we get to Q&A, there may be some people from the other room that are watching live who will come in here for questions. And those of you on Zoom, you can use the Q&A function to ask questions, and I will do my best to kind of keep track of all of that. And I also want to say big thanks to Director Beck and to the American Constitutional Society, the Latinx Law Student Association, the Public Interest Law Foundation, all of whom are co-sponsoring this event and helped spread the word to students. It's wonderful to see so many of you here in our various heres. And also big thanks to Chelsea Browning, our events coordinator, and our tech team who have worked a lot to figure out the logistics to make this event possible. I want to have enough time for conversation, so I'm going to keep the introductions of my colleagues very short. A lot of you have had one or more of them in class. You can read about them on their faculty bios, but very briefly, we have Professor Dan Conkle, who, and I should say all of them are experts in constitutional law, but I'm going to identify particular areas of expertise for each of them. So Professor Conkle, who has particular expertise in religious liberty issues. Then we have Professor India Tusi, who has particular expertise in criminal procedure and criminal law issues. Professor Steve Sanders, who has particular expertise in the 14th Amendment's guarantees of equal protection and due process. And then Professor Luis Fuentes-Rohr, who has particular expertise in voting rights and the history, especially the Reconstruction era and the post-Civil War amendments to the Constitution. So with that, I just wanted to jump right in. As likely everyone in this room knows, this will be the first full term with Justice Amy Coney Barrett in place of Justice Ruth Bader Ginsburg, as well Justice Kavanaugh, Justice Gorsuch, relatively recent additions to the court. And I'd just like to hear from each of you, maybe just going down the line here, as you think about your particular areas of expertise and the court more generally, what do you think we can expect from this new court as it grapples with the constitutional issues? We'll start with Professor Conkle.
Thank you. I'm actually going to speak even a little bit bigger than that. I'd like to just offer two distinctions to keep in mind. Notice the title of this event, What's Next for the Constitution and the Supreme Court. Distinguish between the Constitution on the one hand and the Supreme Court or constitutional law on the other. If you think about recent events, apart from the Supreme Court, think about the norm-breaking behavior of President Trump. Think about his refusal to accept the result of the 2020 election. Think about the January 6th assault on the Capitol. More generally, think about our polarized society and arguably the increasingly problematic and fragile nature of our constitutional democracy. Those are huge issues. Lawyers and the courts have something to say about them, but citizens generally have more to say about them, and political leaders have to step up if we're going to deal with those very big constitutional issues, whether or not they are legal issues. Second, as to constitutional law in the Supreme Court, distinguish between differences in judicial philosophy or ideology and partisan differences. Amy Coney Barrett, just this past week, gave a lecture at the University of Louisville worrying that the public is beginning to think of the Supreme Court too much as a partisan body, commenting further that, in her view, judicial philosophies are not the same as political parties. To say the court's reasoning is flawed is different from saying that the court is acting in a partisan manner. Okay, a bit of historical perspective. I'm older than I look. The mask helps. I've been in my academic career since 1983. The Supreme Court throughout that entire period has been dominated by appointees who were nominated by Republican presidents. Okay, here's a thought experiment or maybe a multiple choice question. 1973, the Supreme Court decides Roe versus Wade. How many, if any, Republican president nominees on the Supreme Court at that time voted in favor of the Supreme Court's result? 0, 1, 2, 3, 4, how about 5? Okay, the court at that time was 6-3 Republican appointees. 5 of the 6 voted with the majority in Roe versus Wade. Of the 3 Democratic appointees, 2 voted in favor, 1 was in dissent. Okay, so the Supreme Court at that time, and really through much of my career, has not heavily identified as Republican versus Democrat. There have been significant philosophical and judicial ideology differences, but a number of Republican appointees embraced judicial philosophies that could not easily be described as quote unquote conservative. You had John Paul Stevens, for example, appointed by Republican President Ford. You had David Souter, appointed by the first President Bush. You had Justices O'Connor and Kennedy, appointed by Reagan, each of whom in various respects issued decisions that in some circumstances might be described today certainly as being on the liberal side of the spectrum, if you want to think of it in those terms. Justice Kennedy, for example, authored 5-4 decisions on gay rights, including the same-sex marriage decision in Obergefell. More recently, with the retirements of Stevens, O'Connor, and Kennedy, we increasingly have this sense that the court's judicial philosophy, the philosophies of the justices, tend to line up with their political party. And that's what Barrett, I think, is properly concerned about. And sort of to take it back to my earlier distinction, and I'll wrap up, basically, if you think about the survival of constitutional democracy, we need respect for the rule of law. To have respect for the rule of law, we need respect for the Supreme Court as a neutral arbiter of constitutional and other legal issues, not necessarily without philosophical differences, but certainly not a partisan body. And to the extent that we have the risk of a partisan Supreme Court, that I think places further at risk the very character of our constitutional democracy. And I don't want to be too dramatic, but President Bill Clinton, a Democrat who sometimes worked with Republicans, famously described a law that he was in favor of as ending welfare as we know it. And again, not to be too dramatic, but I hope we're not the generation that ends democracy as we know it.
All right, Professor Doocy, I hope so too.
Well, I agree with Professor Conkle in terms of the nature of the threat to our democracy right now and the importance of a Supreme Court that people support and view as legitimate, especially because there's a rise in authoritarianism around the globe right now. And, so there is a real threat in terms of, even we saw it in the Capitol Hill riots, in terms of people resisting just the ordinary process of, within our constitutional democracy. So the threat is there. And I think, the Supreme Court has always been political to some degree. There have always been politics involved in the Supreme Court. There have always been debates about whether certain justices are acting in a political manner. But right now feels very different for me. And I think, part of the reason why there's this concern about the partisan nature of the Supreme Court is because of, some of the ways that partisan politics has really been a part of the process of selecting Supreme Court justices more now than even, in the past. So when we think about the political maneuvering of Senator Mitch McConnell, and when we're talking about, Merrick Garland, and even with Justice Amy Coney Barrett, well, I think for many people, that really highlighted the ways that politics are really becoming a part of, how we're selecting Supreme Court justices. At the same time, we also have the elimination of the filibuster, right? And so now this perception that the Supreme Court isn't just this independent body, that is this body that politicians are using to politic, you have this invitation for, a real transformation of the court, because people are concerned that this is not a legitimate court, that the normal processes are being avoided, and that if we allow for these processes to continue to be subverted, that we're going to have this real threat manifest itself in a way that Professor Conkle is suggesting, that we may end up really losing our democracy. And I think you can't think about what's happening with the court without also acknowledging what's happening in politics in this moment, in terms of the undermining of the access to the right to vote, the undermining of other sorts of rights that are happening right now. We have to think of them all together. And I think that's part of the reason why there is this concern around the legitimacy of the court. Now, in terms of what we can expect from the court, I think Professor Conkle's remarks really highlight that it's really hard to predict what an individual justice is going to do, or what they're going to evolve into during the course of their time as a justice. There have been a lot of surprises. I think people might have been surprised by Justice Stevens. They didn't necessarily think when he was appointed that he would end up where he was ideologically towards the end of his term. And so I want to say it's difficult to predict. However, there is a sense that, as things have become more and more partisan, and that perhaps, people are being screened based on their ideological commitments, that perhaps that sort of evolution, or people, really making their rulemaking based upon philosophy rather than ideology, maybe we're not going to see that anymore, right? Where we really are just we really are just seeing, partisan justices being appointed to the Supreme Court. So I think there is a real threat. I'm not sure where the court is going to end up. I think it's worth noting that, before Justice Ginsburg passed away, if you use this typical liberal conservative kind of division for the court, which is helpful, especially for a lot of the more controversial cases, that Chief Justice John Roberts was the medium perspective on the court at that point. And now, using that typical kind of divide, Chief Justice Roberts is more liberal, right, given the current composition of the court. And so that, given the ways that the American public has evolved in this time, right, in terms of people's views, there's a mismatch between the ideologies of the people on the court versus the ideology of people in the American public. So I think, these different political issues are really starting to impact the perceived legitimacy of the court, and, may have real implications for us in the years to come.
Professor Sanders.
Now, in addition to the first-year con law class, I occasionally teach a seminar on constitutional interpretation, and we explore originalism, the living Constitution, et cetera. And I have become a believer myself in what's called the dialogic understanding of constitutional interpretation. It's roughly this idea that over the long run, the constitutional law we get from the Supreme Court reflects a sort of ongoing dialogue between the court and the country. It's a variation on the living Constitution, but it's not this idea that judges just make it up and give us the law that they want. It's that, the court, sort of the social and tectonic plates in our social and cultural history get reflected on the court and are impacted by the court. And a couple of examples. 2 years ago, I wrote an article arguing that the court's, three of the court's major gay and lesbian rights decisions reflected this idea that over time, court decisions had advanced gay rights, but the public had clearly also, really dramatically changed its understanding of LGBTQ rights, and that was reflected in the court's language about dignity and the demeaning nature of these laws that targeted gays and lesbians and said they could be criminalized and couldn't marry. I think that reflected, again, a sort of not just, well, the court sticks its finger in the wind and is responsive to public opinion, but the court is in a sort of long-term dialogue with the public. When I teach the abortion cases, I show my students a graph of public opinion that shows since Roe versus Wade, public opinion has been remarkably stable. Basically, a fairly strong majority of Americans support access to abortion, but don't think it should be just freely on demand, but they also don't want it banned. That basically describes the law that the court has given us up until now. The sort of guardrails are, that keep the court from, just drifting with public opinion are respect for precedent, fear of backlash, concern over its own legitimacy, the reality that presidents get to make appointments to the court, that the court is not insulated from politics in that way, and also the possibility of, congressional backlash. There are things Congress can do to the court if it strays too far out of line with the mainstream. Well, I fear we may be on the verge of, getting a court where these things are not going to be reliably true anymore. What about legitimacy and caution? Chief Justice Roberts has been the main exemplar of that, I think, in a lot of ways, of caution and concern for the courts, how the court is viewed and all that. But as Professor Thusi said, John Roberts has found himself outflanked in some major decisions, including the Texas abortion order, by the court's conservatives. What about respect for precedent? Well, there's a lot of commentary these days on what's become called the shadow docket. The court rendering significant, important, substantive guidance to lower courts, not with a traditional case that's fully briefed and argued, but on a more limited briefing in an emergency order. That's how the Texas law was allowed to go into effect. The court last year made a fairly significant, I think, Professor Conkle could add to this if he wants, a change in the understanding of religious liberty law through one of these decisions on the shadow docket, rather than a true precedent. So is respect for precedent still going to be a sort of guardrail that keeps the court from going off the rails? And then finally, we have this kind of weirdly counter-majoritarian political system right now. One of the guardrails in dialogic theory is that, well, presidents, the presidential appointments and the confirmation process assure that the court will be, to some extent, accountable. Well, 5 of the current justices on the court, 5 of the 9 current justices were appointed by presidents who had lost the popular vote, George W. Bush and Donald Trump. So what does that tell us? President Obama was basically robbed of his opportunity to make an appointment to the Supreme Court. And then finally, we've heard something, there was some talk during the campaign about packing the court. There are other things Congress theoretically could do. It could limit the court's jurisdiction. It could prohibit the court from hearing certain kinds of things. But, Democrats control the court and, control Congress, and that pretty much represents the will of the majority. But Professor Thusi also talked about the filibuster and the Democrats can't sort of impose their view of the law or bring the courts to heel in the way they think might be appropriate, even though they have a majority because of the filibuster. So, as I said, I worry a little bit about this idea that we can always kind of count on the court to not get too far out or too far behind where the public is. We may be moving into a zone where that's no longer a reliable assumption.
And Professor Fontes.
Thank you. I got to tell you, I took a chance. I thought, I sit to the left or I sit to the right. When you sit on, hoping, I should have talked to her beforehand, hoping that I'd go not last. Because when you go last, all your points get taken by the others. So I'll do what I can to, in fact, I'll take less time than I would otherwise because my points have been taken from me. And lots has been said, by the way, that I want to sort of highlight maybe, and I have questions for my co-panelists, but we don't have that kind of time, unfortunately, but they said so much so interesting that I wish we could actually have a conversation maybe sometime in the future. So here's the way I think about what's happening right now. In 2016, I thought to myself, this is interesting. Here's Obama appointing or nominating a judge for an open seat on the court. And then people will kind of upset, some folks, because, as you remember, the Republican Senate refused to confirm or even put the nominee to a vote, which is almost unprecedented. And people didn't quite understand how that could be possible. And so at that moment, I remember thinking to myself, I wished, and I think I was right about this, and in fact, somebody came to this room and made the same point, and I thought, again, happens to me apparently all the time, that is my point. I thought to myself, I wish they wouldn't fill that seat. In fact, please take it away. The reason being, if you take that seat away, the court turns 4-4. It either forces them to compromise, or else they don't get to do anything. Go ahead, go 4-4 into the foreseeable future, see what happens. And I will not ascribe blame, by the way. I think I was right, though I always usually think that, so that doesn't tell you much about that example. But that said, today I kind of think about that moment. And I think about a second moment. I thought, fine, go ahead and fill the seat, next president. If you do that, what is going to happen to the court? And what is going to happen to the court is things that you've heard by my three co-panelists. Here's my view. My view is the court is a strategic actor. The court doesn't stray from public opinion. The court has to worry about other institutions. The court doesn't just live, we think it does, but the court can't live up on that Olympian-type building that we built in such a way for that precise reason. So we think they live in some place that is away, up in the skies, up those steps, away from all of us. The court lives right with us and deals with the same issues that we do. And they have the same views that many of us hold. They have political preferences, the justices do. But here's the problem, right? They have to worry about Congress, they have to worry about the president, they have to worry about the publics that interpret and express their views on the ground. Right? When they say to a school board, do this, the school board may say no. And there's cases here that I could give you, but I don't have that kind of time, unfortunately. But the point is, the court worries about all kinds of stuff, so they behave strategically. And I thought, what's going to happen to the court? Well, the median justice has to worry more than anybody. And there's a whole literature here that I could point you to. I could talk further at some point. Think of Stevens. Stevens, he would have told you, I didn't move, the court and the country moved on me. But they'll say that. Reagan said the same thing. That's what they say. But Stevens became basically the fifth vote, and then he led the court in many ways. Some people called it the Stevens court. Think of O'Connor. She also shifted. Think of Kennedy. He also, maybe not as much as you would have liked, but he also shifted. Think of the Chief Justice. He also shifted. So the point for me for the future, the court can't stray too far. And I take Steve's point about the guardrails. And if I had to ask a question, if I had a question to ask, it would be, Steve, what do you think happens moving forward? The court can't stray. It may be the point that the filibuster maybe is the one moment when this all breaks down, or polarization is the one time where now we don't really have what we had before. Maybe. But surely notice how the Chief Justice can tell you with a straight face that healthcare law is a tax. And then you keep reading and he tells you, oh, wait, but not here. Then it's not a tax. That's the Sebelius case. I'm not criticizing. I'm pointing out he was walking a tightrope. And the tightrope is gone because now he's at best one of four. And so the point moving to the future, who will be the fifth justice, right? We have Stevens, O'Connor, Kennedy, Chief Justice Roberts. So who's next? somebody has to, they've always shifted. Somebody, the median. By the way, Kennedy and O'Connor were in fact super medians, which means something in the way I intended. But the point is, we don't have that anymore, but the court has to work. So then the speech by Coney Barrett, it was so important and it was so expected. You should have asked me, had you seen me down the hallway, what do you think is gonna happen? They're gonna start chirping or talking about the court's legitimacy. They're gonna start telling you about law matters and political philosophy. Of course they're gonna tell you that, because that's what they have to tell you. I don't think they believe that's what they're doing. Some do, some are. But in the end, right, they have preferences. So in the end, behaving strategically means who's gonna be the next one? And I wonder, I have my views, and of course there's gonna be cases where you'll see like the Gorsuch opinion recently, where, or the Native American, the federal statute in Native American reservations from, was it last year, 2 years ago? And so Gorsuch sided with the liberals, and you're like, what is he doing, right? So it's gonna get funky, different, tricky, interesting. And I wonder to the future, who will be the one? Because they've always done it. Because they have the guardrails, they have to do it. So I just wonder, and with that, I could go on forever, boy, could I ever. So I will stop here.
Well, thank you. So many different threads to pick up on, and very real and pressing questions in terms of thinking about this interplay and how things move forward. I'm going to shift to talking a little bit more specific and kind of direct questions at individuals. If you have additional thoughts to chime in, but I'm also going to say it'd be great to cover a variety of questions. So as Professor Fuentes-Rohr has pointed out, unfortunately, an hour goes really fast. So just be mindful of that as you all answer. And I'm going to direct this first to Professor Fuentes-Rohr because he actually also teaches at SGIS and needs to be across campus for a class starting just after 1, so he is slipping out early. So thank you for squeezing this in. And I actually want to start, I think that, we've already heard reference to the Texas abortion case, to the healthcare case, these cases that grab huge headlines. It's easy to sometimes forget that the court decides a lot of other cases that don't grab public attention in quite the same way. But I know one that Professor Fuentes-Rohr is following. And I think it's helpful to think about some of these other less high-profile cases, sometimes because the partisan divides aren't on display in quite the same way, and you see other factors. So one case that's currently pending is a challenge brought by residents of Puerto Rico to the fact that they do not receive benefits under Social Security and a bunch of other benefits programs. And I just wondered, when you look at a case like that, what's at stake, what to expect, and how do we think about some of these kind of lower profile cases in context of the bigger conversation?
The case is called Vallejo Madero, and it's a case that began, as cases do. This case began in New York. The plaintiff is in New York City. He's receiving the supplemental income benefits through the Social Security program, about $800 a month. He's in New York, he's receiving them, his wife, he's from Puerto Rico, he moves to New York, he starts receiving benefits at some point in his life. Then his wife moves back to Puerto Rico, and then ultimately he follows her back at about 20, I want to say 16, 17, it's really irrelevant. Point is, once he's there, he turns 65, he applies for Social Security benefits proper. And as he goes to the Social Security office, they say to him, why are you here? He said, I don't know, why are you here? And, well, you didn't tell us you were here. He said, well, I didn't know I had to tell you anything. Well, here's the thing. When you are in Puerto Rico, you don't qualify for the SSI program. Those $800 that we were giving you for the time you were in Puerto Rico, that was given to you by error. And by the way, you owe us $29,000, 28 plus. So either we'll take Zelle, we'll take PayPal, we will take cash check, but we will take back. And he said, wait, that doesn't make any sense. I am in the United States. No, you're not. Well, you may be in the United States, whatever that means to you. You're in Puerto Rico. On the statute under review here, the statute we're talking about, defines state as the 50 or 48 plus 2 contiguous or non-contiguous states, D.C., and the Northern Mariana Islands. Ask me why. In fact, please don't, because I don't know. In fact, nobody knows. So here's what's interesting about this case. Could Congress do that? So here's what's really interesting. When I first heard about this case, I thought, this is an easy case, because the court, when it comes to the territories, they subject these to the lowest level of review imaginable. And you say, I know what he means. He means rational basis. No, I mean lower than that, which is, no review at all. Zero. We don't even care, basically. The cases that are controlling here, Congress, do what you want. Short of killing them, do what you want. Super interesting. And so here's the question I'm going to leave you with. And again, I could go on for way too long. Here's the issue. This is a question that's been in Congress's hands for years, if not since 1898. There's a set of cases in 1901, the insular cases, where the court said, look, this is a distinction. Territories are divided into incorporated and non-incorporated. So the question is, what are you, Puerto Rico? Well, Congress says unincorporated. That's how they all come into the United States. Until Congress decides to incorporate them, you're unincorporated. And things apply to you in a funky, different way because you're unincorporated. Are you incorporated? Well, you have to be really clear, Congress. We're not going to do it for you, said the court in 1922. Here's the story, which is what's interesting to me. What will the court do in this case? If I were a gambling person, I am not. But if I were, I'd say they're not going to do anything. Why? Because this is an issue that dates back, as I just told you, 1901 to 1922, these insular cases. The court, and again, this is so interesting, and I'm sorry I can't explain all of it for the lack of time, but the point is, at the end of the day, the court is not going to solve the colonial status of the territories via a judicial opinion. That is it's never going to happen. But for the point I made before, strategically, imagine the court saying to Congress, oh, by the way, we just added a bunch of citizens and accorded them full citizenship. So do what you must. And those $5 billion that you need to find in the federal budget to pay for it, good luck. Right? The court's not going to do that. So in the end, what will it do instead, I wonder. But they won't do it either. I was thinking political questions, but of course not. But what will they do? I don't know. But they will get rid of the case in a way that, rational basis, and walk away. In the meantime, the people of Puerto Rico and the territories generally stay in some limbo that is tragic, if not hidden, which is really the worst part of all. And as I said, I could go on too long, so I'll stop here. Thank you.
Thank you. So I wanted to kind of go back, Professor Conkle, to your first point, which I think was a really important one, which is the Constitution is separate from the court, even though we've drifted into sort of being very focused on the court. Have maybe you start, but if others want to chime in, just talk a little bit about, so President Biden just issued mandates, not just that federal employees be vaccinated, which is sort of clearly within the power of the federal government for its own employees, but that large businesses require their employees to be vaccinated or to be tested. And I think, we've seen a lot of support for that. We've seen a lot of opposition for that. A lot of it has been explicitly political, with elected Republican leaders standing up and saying that's unconstitutional. But it also has to do with interplay between the federal government and the state governments and the private sector, and the reality that COVID doesn't, observe any of these lines. And so, it's its own thing. As you think about sort of the vaccine mandates and the issues at stake there, and also the urgency of figuring out what's allowed and not relative to the standard process of sort of going up through the courts. How do you think about that mix of questions to resolve the constitutionality of these orders and pros and cons of, as Professor Sanders mentioned, some of the other COVID challenges have been decided on the shadow docket without full briefing because of the urgency, but then there's a downside to that. But we all need to know what the rules are too. So how do you think about that mix of issues?
That's a complicated question, a good one. But just just to sort of speak to the merits, okay, of the Biden mandate proposed, not yet implemented, on large employers, that employees have to either be vaccinated, and this is, I think, important, either be vaccinated or submit to regular COVID testing. Okay, so that in terms of conventional constitutional law, you have three potential issues. You have a federalism issue which is basically, does the federal government have the authority through an agency, in this case OSHA, to implement this kind of a requirement on employers that they insist upon this for their employees? The answer is yes. In terms of conventional doctrine, the Commerce Power permits Congress to regulate interstate commerce. About 50 years ago, Congress created the statute that set up OSHA. OSHA has the delegated power to implement worker safety regulations, so the Commerce Power doesn't seem to be a problem. If, on the other hand, and this goes back to the Obamacare ruling that I think Professor Sanders mentioned, I mean, if the federal government somehow tried to implement a general mandate for all citizens to be vaccinated, that might be a federalism problem in light of the Obamacare ruling that said the federal government can't tell people what to do. It can only regulate activity. In this case, the government would be regulating activity. The employment relationship, I think, would clearly qualify. So federalism, I think, would be a losing argument unless the court radically shifted its doctrine. Separation of powers basically asks the question, does OSHA properly have delegated authority to implement a vaccine requirement, albeit with the testing alternative, as part of a workplace safety authority? Again, I think probably yes, it does. At the same time, the Supreme Court more recently has been stingier than it used to be in construing the scope of authorizing statutes that authorize executive agencies to do things. Most recently and most notably, a shadow docket ruling in terms of the moratorium on evictions. The Supreme Court said that the CDC, it's complicated, but basically the CDC did not have the authority to impose on its own a eviction moratorium under its delegated power to prevent the interstate spread of disease. Supreme Court said that goes too far. So who knows? I mean, if the Supreme Court were aggressive, it might say OSHA is about things like wearing, particular types of protective equipment. It's not about vaccines. Again, I think that's probably a tough argument. Likewise, the third prong of an attack would be some kind of an individual rights argument that, the employees cannot be required to submit to these vaccines. Again, you got the testing alternative, which makes the employee's case weaker. There's an old Supreme Court case dating back over 100 years that permitted a city in Massachusetts to mandate that everybody get a smallpox vaccine. Everybody, every adult citizen would not, regardless of whether you're employed or anything else. So that the general individual rights argument is tough. Religious exemptions is a huge issue. There is a provision in federal law that says that employees must reasonably accommodate to their employees' religious practice, but they don't have to do that if it would impose undue hardship on the employer. Employer, I think here could pretty strongly argue to permit a religious exemption might in fact impair our workplace safety. They don't want to do that. They'd rather grant a few exemptions perhaps. In any case, that could very well be litigated. You got all kinds of sincerity issues. You just have to read the newspaper or look at the news and see how those issues are in fact arising. So basically, I'd say in terms of the merits, I think generally speaking, the Biden administration is on pretty strong ground. How that gets resolved, how quickly, shadow docket and all that, maybe someone else would like to comment. I don't know how that's going to work its way through.
Does either of you want to weigh in on that?
Not on that issue. So.
Just kind of looking at other recent headlines, and sort of, I think also the limits of the Constitution. Professor Tuzzi, as I said, you focus on criminal procedure and criminal law. For a long time, but certainly since the murder of George Floyd, there's been a real scrutiny on systemic racism built into the policing system. And most of that has called for reforms of policing rather than rethinking the substantive constitutional law that governs it. What should that interplay look like, do you think, as you think about problems exposed? And is it just about criminal procedure and those amendments, or does the Equal Protection Clause have something to say when you start thinking about systemic racism?
Well, the Equal Protection Clause definitely has something to say about it. We should eliminate it, I think. But, just focusing first on the Fourth Amendment doctrine, part of the challenge, a lot of the criminal procedure cases have actually empowered police, made it very difficult to regulate the activities of police officers. And, I want to focus on one remedy that a lot of people were kind of advocating for short after George Floyd's death, and that was ending qualified immunity. And so that's a doctrine that comes out of the Supreme Court. Qualified immunity ensures that law enforcement officers, even though they have violated an individual's constitutional rights, they're still immune from civil liability if that right that they violated wasn't clearly established as a violation of the law. And the ways that lower courts have interpreted this doctrine is that they will look for other cases that match the facts of the particular case before them. Sometimes they're looking for facts that are identical to the case before them. And then if they don't find another case that's similar, they'll say, well, while this was a violation of someone's constitutional rights, it wasn't clearly established that this would be a constitutional violation. Therefore, this law enforcement officer is entitled to qualified immunity. And so after George Floyd's death, there were a lot of groups advocating for the elimination of qualified immunity, and a cross-section of groups, conservative groups, liberal groups, came together around 3 different cases that would be presented to the Supreme Court for cert that provided an opportunity to end this doctrine of qualified immunity. So these cases were presented before the court. The different advocates sought cert review. The court pushed back the conference when they were supposed to actually consider these cases multiple times during the course of the spring of 2020. Now, June 2020, where people, a lot of groups were actually really optimistic, especially since there was such a cross-section of groups calling for the end of qualified immunity, presenting both an originalist account as to why qualified immunity should be eliminated, presenting a progressive account as for why qualified immunity should be eliminated. And the court, and I guess this is kind of going into this, common theme about the ways the court is making decisions just using the shadow docket or just in its denials of cert, just denied the cert petition in June 2020. And, this obviously was very upsetting because it was soon after George Floyd's death. There was no real explanation as to why the cert was denied. And the only person who dissented from it, which is interesting and kind of goes to the ways that, ways we think about conservative and liberal, doesn't match up in all areas. And criminal justice is definitely one of those areas. Well, the person who filed a dissenting opinion was Justice Thomas. And Justice Thomas was the only person who presented a dissenting opinion, and he stated, this is the opportunity to finally deal with this doctrine. Why aren't we dealing with this doctrine? Now, fast forward some, though, what we have been seeing with qualified immunity, a lot of action in the shadow docket. So while the court did not take the opportunity to hear a case on the merits that might allow it to eliminate qualified immunity, it has been regulating qualified immunity through these decisions where it's granting cert, vacating the judgment of the Court of Appeals, and then remanding for the Court of Appeals to reconsider in light of its decision. And it's been doing this in really egregious applications of the qualified immunity doctrine. And so one case is Lombardi v. St. Louis. In that case, there was an individual who was arrested and put into jail. There was a concern, officers were concerned, and the correctional officers were concerned that this person was going to try committing suicide, and there was evidence that he was trying to attempt suicide. So they went into his jail cell, restrained him. He was about 5'3" and 160 pounds. They restrained him, and they restrained him so long, they were all on top of him, and he died as a result of this restraint. Now, the Supreme Court, in a per curiam decision, right, and so in the shadow docket, vacated the Eighth Circuit decision, and it stated that it was not clear whether the Eighth Circuit was trying to suggest that this type of restraint was per se constitutional if the person who was being restrained resisted in some way. And it said that the Eighth Circuit needs to go back and reconsider because there are circumstances where someone's restrained, might be fighting back, where it's nevertheless, the officer won't be entitled to qualified immunity. And what was interesting in that case, especially in light of the, Texas abortion case, is Justice Alito wrote a dissenting opinion complaining that the court was using its shadow docket to rule on something that was substantive. And I can quickly look at what Justice Alito says. Justice Alito said, "Without carefully studying the record, I cannot be certain whether I would have agreed with the Eighth Circuit panel that summary judgment for the defendants was correct. We have two respectable options: deny review of the fact-bound question that the case presents, or grant the petition, have the case briefed and argued, roll up our sleeves, and decide the real issue. I favor the latter course. But we should not do is take the easy out and that the court has chosen." Now, this is really ironic in light of the recent decision, right? And what it can suggest, especially for people who are closely following the court, there are concerns that the justices aren't being completely consistent with their own kind of stated philosophies or approaches to the law, right? And so here, Justice Alito's expressing a lot of concern about the shadow docket, where it's allowing qualified immunity, where it's preventing qualified immunity for a law enforcement officer, whereas, in the most recent case, where it was very substantive as well, those concerns didn't present themselves. So, in terms of, go back to your question, what role does the court play? It seems that the court isn't willing to, at least on the merits, take bold action, but there does seem to be some regulation, especially when there's egregious cases in the criminal justice area, to kind of curtail qualified immunity in particular.
Thank you. Okay, so I'm mindful of time. I wanted to save at least 10 minutes for Q&A, but I haven't given Professor Sanders any sort of individualized question. So I think what I'm going to do is ask if you want to comment maybe briefly on the abortion decision. And I think this is maybe a place where those guardrails you mentioned are coming off, because, certainly the Texas, and depending on what they do in the case coming out of Mississippi, they may functionally be banning all abortions, which is not in line with public opinion. And so if you could maybe briefly comment on that or other issues. But at the same time, if you have questions on Zoom, and if you want to open them, or in the room, if you want to line up here, or in the other room, if you want to come in, you can line up at the microphone, and we'll try to at least get a few questions in. So, Professor Sanders.
So with the shadow docket ruling and the abortion case, I mean, you did have this kind of unusual configuration of the Chief Justice joining with the three more liberal members of the court. Earlier this year, you had a unanimous decision on a sort of clash between religious liberty and gay rights, but there was it was a very narrow gauge decision. It didn't decide a sort of big enduring issue. And various of the court's conservatives kind of, although they joined the judgment, had different views about, how the court should have arrived at it. I guess I just want to conclude by, he's not here anymore, but maybe disagreeing a little bit with Professor Fuentes-Rohr when he said, well, who's going to be the median justice? I'm not sure there has to be one. I mean, yes, it was O'Connor and Kennedy for a long time, but if you look back at the Lochner court, that was pretty solidly ideological in one way. If you look at the Warren court in the 1960s and 70s, or 50s and 60s, that was pretty solidly ideological in one direction. I think what we're likely to see, yes, the court has become more conservative, but I don't see that sort of one single intellectual leader has emerged out of that group. You've got Alito, who's sort of a results-oriented conservative, Thomas, who's sort of a paleo-originalist, Gorsuch, who's sort of a more modern textualist, Barrett seems thoughtful, but I'm not sure, a true judicial philosophy has sort of emerged yet. So I think it's going to be interesting to see, and I think, it's not going to be a simple story. I think we will see interesting coalitions coming together, and occasionally maybe Chief Justice Roberts prevailing on his colleagues to decide something narrowly rather than going broadly. But I don't know that we have reason to think there is going to be this sort of kingmaker median justice like Justice Kennedy played for so long, or that the conservatives on the court are going to unify necessarily around one particular approach to the Constitution or to statutory interpretation.
Okay, so we're going to shift into questions. We have at least 7 minutes, though maybe we can go a little over, but I would just say, questioners, please try to be concise, and answerers, please try to be concise. And I will also say, for those on Zoom or anyone in the room seeking CLE, the code is 23147. that will be in the chat as well, but 23147, which you need for CLE. Okay.
All right, so I'm going to try and ask a question that I also asked the panel yesterday, well, a version of it. So, Professor Sanders, you mentioned how you interpret the court's approach as like an extended dialogue to sort of bring in their interpretation of the Constitution within modern consensus of the people, basically. How much do you think that approach, if at all, is influenced by the near impossibility of actually amending the Constitution in modern day, especially compared to the constitutions of other countries or even our own states? Yeah. Do you think some justices see the court's responsibility to basically amend the Constitution to bring it into line with the strong majority of public opinion because citizens don't have a way through, a realistic way through democratic process to do so? And on the flip side, if the U.S. Constitution could be amended through a more direct democratic process like referendum, do you think the court would take a more solidly letter of the law textualist approach?
Yeah, I think it's hard to predict that. I mean, I don't think that the court lives in fear of any sort of constitutional amendments because it's just too hard to, especially in our polarized times, we're not, the country is not going to agree on some kind of substantive constitutional amendment, whether it's about religion or abortion or something like that. So I guess the short answer, I just want to conserve time. I'm not meaning to sort of be flippant about it, but I don't think the court thinks about the possibility of the Constitution being amended. But I do think, there is evidence of what Bruce Ackerman has called constitutional moments where sort of the court does, change the meaning of the Constitution almost as if it had been amended. And I think, we may continue to see that. I just don't see Article 5 style amendments playing any sort of serious role. It's just too hard.
Mm-hmm. Okay, thank you.
Excellent, concise question and concise answer. Well done.
I'll try to stay concise too. It actually relates to that, which is, I'll bring this down to the statutory level. The board, the National Labor Relations Board, has been criticized as being too political. And I think in part that has happened because we have not been able to amend the statute for decades. And as a result, the board, the only way we change the statute is by changing the amendments or changing the interpretation, and they don't have to worry about being overturned by Congress now. So back to the problem about how do we keep this car on the safety lines and keeping it in bounds, has the court in fact become more political than in the past? And if so, is part of the problem that Congress doesn't work as well as it used to? And if Congress worked better, so in terms of how do we fix this problem, one thing we should be looking at is how to make our democracy work better so that the court isn't put in all these situations to decide these issues.
I think your point's well taken. I mean, if you think about, for example, the ruling that Justice Gorsuch authored extending the Civil Rights Act to sexual orientation and gender identity, I mean, in a different era, that would have been a congressional amendment. So I do think, those things do interact, and I don't know what's the cause and what's the effect, but a dysfunctional Congress, I mean, you can also think about, basic separation of powers, war power. Okay, we've got an authorization from 2001 that presidents, right through President Biden, are still relying upon, that was dealing with, Al-Qaeda in a particular setting, and Congress hasn't yet been able to deal with it. So I think dysfunctional Congress is a big part of it. I don't know if that's totally responsive, but.
I agree.
Mm-hmm.
My question has to do with Justice Coney Barrett's comments the other day and how she spoke rather flippantly of the media and public opinion being too conclusion and results oriented. Going to that guardrail analogy, do you think that's indicating that the court feels a little less bound by those constraints nowadays? And if that's the case, what would that mean for the court going forward?
Do you want me to? Go ahead.
Justice Amy Coney Barrett at the Mitch McConnell, Center at the University of Louisville, with Senator Mitch McConnell introducing her, who facilitated her appointment to the Supreme Court during the election as early voting already started, complained about the partisan nature of the court. I don't think I need to say anything further. I mean, maybe one of my colleagues can contribute. I mean, sometimes I read that, and I think a lot of people read it and were a little bit stunned by it, even the context in which, she was making these remarks. But, some of it is just, a bit of performance, right? I mean, the court justices require, they depend upon a perception of legitimacy. They can't go into the court and say, I'm partisan and that's why I'm here, right? They have to assert that they're being neutral. But I think, in fact, and I'm not sure that this is so different from, prior years, that, a lot of justices, when they see a case, they have an idea of how they're going to resolve that case. And some of the work is just figuring out how to get to that end result, right? But I'm not sure, I don't take her comments as reflecting a substantive commitment to, preserving the legitimacy of the judiciary. But maybe I'm just a bit cynical.
I might give her a little bit more credibility, perhaps. But basically, I mean, there is an argument, at least, that the appointment process is not a judicial process. Likewise, the resignation of a justice, Justice Breyer has commented upon this recently as to whether he should resign to facilitate an appointment by President Biden. And he quoted Chief Justice Rehnquist, a Republican, as earlier saying that the decision to resign is not a judicial act, so that it's okay to be partisan if you're making a decision like Breyer might make to resign. Arguably, the appointment process is not a judicial act either. Whether she should have appeared, with McConnell introducing her, maybe wasn't terribly prudent under the circumstances, given what she wanted to say. But I do think one can at least make an argument that once you're on the court, you're not supposed to be partisan. You have your own judicial philosophy. You may be a strong supporter of states' rights. For example, suppose that you had a Republican president who issued a mandate, unlike Biden is doing, that says, we think it will be counterproductive for employers to mandate vaccines. Therefore, we are going to preclude large employers from mandating vaccines, and assuming he had statutory authority to do that, if the justices would change their mind on the constitutional issues of federalism or separation of powers based upon whether it's a Republican president or a Democratic president, that would be partisan. If they have a philosophy of separation of powers or federalism, they might be wrong, or sound or unsound, but that would not necessarily be partisan. Just as a footnote, I've seen a suggestion that Roberts, interestingly enough, might be described as partisan if, in fact, his thinking is, if the Supreme Court goes too far, this is going to hurt the Republicans in the midterms and hurt the Republicans in the next presidential election. So he wants to keep the Supreme Court from going too far to the right so that the Republican Party does better. That would be partisan, even if it would be, from an institutionalist like Roberts, arguably keeping the court properly in check.
All right, I'm going to invite our final question. We are a minute or two past one, so if you have to slip out, but please.
So, given the guardrails that Professor Sanders described, to what extent do you see the method of the Texas legislature in the recent abortion ban as a means for the court to not have to dirty their hands and instead simply feign inability to stop unconstitutional laws due to procedural processes and strategies designed to accomplish unconstitutional ends?
Yeah.
The way I see that as fitting in is, so the court has not, decided the substantive issue of abortion. At least they purported that's what it wasn't about. They just said they were flummoxed by how they could enjoin this law because of the way it was written. But I do think that we're in such an extraordinary situation of a state now essentially being able to, take away a constitutional right, that respect for precedent is one of those things I said is a sort of, keeps the court in check, even if you believe in a living constitution or a dialogic view, to tolerate the idea that a state could do this. They could have said, we're not going to decide the substantive issues, but this is too big an issue. This is too much of a slap in the face at us to let this law take effect, so we're going to put it on hold until it is fully briefed and and fully argue. I don't know if that answers your question, but I think that gets to the question of, how serious are we that there are precedents, longstanding precedents that establish, key constitutional rights that we're not going to let a state, even if we say, well, we need time to think about it, brief it, bring it to us whenever the lower courts are done, you just can't let a state get away with that, I think.
And with that, I'd like to thank our panelists and thank our audience and thank everyone else. So wonderful.